Hello friends. Today we'll talk about Contempt of Courts Act 1971. This is my favorite act. Why? Because the judiciary is treated as a temple of justice. Every court is a temple of justice. All right, because millions of Indians they knock the doors of the number of courts across India for justice. Okay, and dispensation of justice is a very noble thing and it's a very divine thing. That's why the lordships they tiringly work day and night, okay, and in order to deliver justice to the people of our country. Okay, we should appreciate and we should be very thankful and grateful and obliged for such kind of judicial services what the judges usually deliver in our country. So the judgments of the judgments and the orders delivered by the courts across the country are governed by this particular Contempt of Courts Act. There are two things in each and every judgment, particularly the judgments of the High Court and the Honorable Supreme Court. That is obiter dicta, as this is called the doctrine of stare decisis. One is obiter dicta and the second one is uh, like uh, obiter dicta and I'm sorry, I forgot. Ratio decidendi. Okay, that is the reasons. Obiter dicta is the, what do you say, the observations of the judgment, and whereas the ratio decidendi is the reasons. So both of them form a judgment. When these two things are given on particular question of law, then that becomes binding. Not the facts and circumstances of the case are irrespective and they are irrelevant, because every case is different from each other. But what matters is only question of law. So let us come to this particular act of Contempt of Courts Act 1971. And there are two types of contempts, my dear friends. One is civil contempt and another one is criminal contempt. Civil contempt occurs when a judgment or an order of a higher courts, constitutional courts, is violated. All right, and for civil contempt to qualify, there has to be four ingredients. The point number one, the order has to be there. Point number two, the knowledge that this order exists has to be there with the contempt, or if somebody is violating and you're accusing him of committing contempt of court, then he should be well versed with the knowledge that this order is there. The simple thing is you have to put him on a notice, then he will have the knowledge. This is the second thing. And third thing is he should have that capability to implement that order. It should not be that he is not in a position to implement that particular order of that particular honorable high court or the supreme court or the courts below. He should be empowered to implement that order. And number four, he should be deliberately and intentionally violating that order. So if these four things qualify, he is liable for civil contempt and he will be punished. These definitions are there in section, that the definitions are there in the 2A, B and C. B is civil contempt, C is criminal contempt. So 2B we are talking about, this is punishable from section 10 to 12. All right, so the next thing is, if you talk about the criminal contempt, if somebody is passing lewd remarks about the judiciary or the judges, about their functioning or such kind of unparliamentary things, or publishing some kind of objectionable content, then they are liable for criminal contempt. Or not only that, if somebody, this is very important, this is rarely used in the Indian judiciary, if somebody intends or tends to interfere with, this actual definition, or obstructs or tends to obstruct the administration of justice in any other manner. Alright, scandalizes or tends to scandalize or lowers or tends to lower the authority of any court, prejudices or interferes or tends to interfere with the due course of any judicial proceeding. If you go to a court and misbehave over there, if the judge is trying to deliver justice to the people across the office hours, or even after that, if you are trying to interfere with him and if you are trying to obstruct the proceedings of the honorable court, then you are liable for this kind of criminal contempt. All right, so never talk unless you are authorized to talk in the court, number one. And number two, never address particularly the constitutional courts without any authorization. All right, even if you are an advocate or a non-advocate, the authorization has to be there. The court should permit, okay, for your humble submissions whatever you are making. All right, if you try to misbehave over there, and if you try to talk to the judge in whatever way you like, if you don't maintain the decorum of the court, if you wear whatever casual wear, whatever you want, and go to the court, such kind of things are not, I mean, authorized, they are not acceptable in the courts of law, so you have to be very careful. This comes under the criminal contempt. And not only that, even the perjury qualifies for this 2C definition: interference or tends to interfere with or obstructs or tends to obstruct the administration of justice in any manner. So therefore this is treated as contempt on the face of the honorable high court or supreme court. All right, this section is being dealt with section 14, procedure where contempt is in the face of the honorable supreme court or high court. So what is the punishment? You have a simple imprisonment of 6 months, and also a fine of rupees 2000 for the civil contempts. And in criminal contempts, what happens, like there can be heavy fines or penalties that can be imposed by the honorable high courts and the supreme courts if you do the contempt on the face of the those honorable courts. All right, apart from the punishment. All right, my dear friends. And not only that, the next thing, if you are sentenced by any chance, this usually happens mostly to the government officials. Private people are less implicated in this. Government officials, they disobey the orders deliberately. So in such kind of scenario, they are punished by the respective courts, and they have only one chance, that is only one appeal is allowed, unlike in other cases. In this case, if a single judge delivers of the high court delivers a judgment convicting, then you can go to the division bench. That's it, there's the end. If a division bench convicts you, then only the supreme court of India can hear your appeal. So there is in through by way of only an SLP. So again, these are the only options. So one has to be very careful in dealing with the judgments and orders or of the honorable high courts and the supreme courts, even lower court as well, my dear friends. All the courts have to be treated with great respect. And the next thing what I'd like to tell you is contempt by a judge, magistrate, or any person acting judicially. Even a judge is also liable for contempt, particularly like if you talk about the subordinate not subordinate courts. In the trial courts, if at all they don't implement the high court orders or the apex court orders, normally they will come into the loop, and on the administration side they will be punished. All right, and for contempt also, suo moto, it can be initiated by the court itself. And if at all you want to file any contempt case against the magistrates or the district judges, it is first of all not advisable. If there are provisions, because very few people are filed such kind of things in our country, but the consequences will be very harsh unless and until there is some kind of deliberate violation by those concerned judges. It cannot be entertained by the higher courts, whether it's high court or the supreme court of India. So it's not advisable, as I said you. Apart from that, there is one more thing called Judges Protection Act 1985 that gives immunity to the judges. All right, if a high court judge is not obeying the supreme court order, you can hardly go for an appeal instead of a contempt. The honorable apex court will examine. If they find something is seriously wrong with that, if it was adjudicated per incurium, that is without caring the binding precedents of the honorable apex court, then they will if they feel like, they will initiate some kind of transfer or some kind of actions. That is up to the honorable apex court. That nobody has got right and nobody can question that. All right, so as I told you, subject to the provisions of any law from time being in force, a judge, magistrate, or other person acting judicially also be liable for contempt of his own court or any other court in the same manner as any other individual is liable. And the provision of this act so far as may be apply accordingly. Nothing in this section shall apply to any observation or remarks made by a judge, magistrate, or other person acting judicially regarding a subordinate court in an appeal or revision pending before such judge, magistrate, or person against the order or judgment of the subordinate court. All right, and that's it. Subject to the provisions of any law from time being in force. So as I told you, any other law means the Judges Protection Act. So there is nothing much. And if at all, if it's about the trial court judges, if you are going against a contempt in the higher courts of supreme court or honorable high courts, then what happens, like at the most, like they will be taking action on the administrative side. Okay, the registrar generals or the secretary general, they will be responsible for dealing such kind of issues. So don't expect much. If at all you've been the concerned trial court judges have adjudicated your manner in a prejudiced way, and which have put you into lot of irreparable injury. Why? Because they have not followed the judgments of the honorable apex court, or they have passed the orders per incurium. Note this word, it's per incurium. Recently, there was a Supreme Court judgment itself in Bilkis Bano case. In the year 2022, the same very honorable Supreme Court has passed an orders in favor of Bilkis Bano convict. Okay, saying that the Gujarat government can consider as revision application. But now, yesterday, the Honorable Supreme Court has heard various writ petition criminal, a batch of petitions and pills as well, challenging the remission of those Bilkis Bano convicts, and has termed the earlier judgment as per incurium. And the first time, I should say, one of the biggest things in the first time, this much of gravity, fraud has been played on the Honorable Supreme Court. This is what Supreme Court itself is saying. Because see, people who play fraud, the Gujarat government was accused for this. People who play fraud, okay, and obtain the orders, the court will not be responsible for that. If we cheat judges and take some orders, we are responsible to face the music. It's not the fault of a judge, because judges always act in favor of, with the face value, and in favor of the litigants as well as the counsels. All right, they go through the records, and sometimes they might also have, they are also human beings. Sometimes they can also be taken for a ride by selfish and like you can say criminal and elements. All right, such kind of delinquent, I would say this is the best word what the honorable Supreme Court has coined, that is delinquent counsels, delinquent litigants. In such kind of scenario, we ourselves, whomsoever the delinquent people are there, they themselves are responsible for such kind of fraud, and the action will be very serious, my dear friends, because the honorable apex court takes such kind of frauds on the court very seriously, because that is as I already told you, that is section 14 of the Contempt of Courts Act procedure, where contempt is on the face of the High Court and or Supreme Court. And my dear friends, there was a recent judgment, I think it's Balwant Bhai, I think, of the Honorable Apex Court. The Honorable Apex Court has categorically held, it has given an obiter stating that anybody who is involved in the contempt, even if they tender an apology, the high courts should not accept it at the face of it, just because the person is scared of going to the jail. That's why he is tendering an unconditional apology. Therefore, that apology is liable to be rejected. So mind you, the Contempt of Courts Act is very dangerous, and this has been incorporated into the statute book, so that in order to instill faith in the public in the judiciary. Alright, as I already told you in the beginning, the courts are temples of justice. All right, because so many people in our country are facing lot of litigation and lot of problems, and there is only justice and nothing less than justice can solve their issue. The justice has to be delivered, and the honorable courts are already there to deliver the justice to the deserving people, and truth will prevail and justice will also prevail. There is no doubt about it. Just like Bilkis Bano, it took 2 years for her to fight. Ultimately, justice was delivered. All right, the binding precedents were violated in that particular judgment also. So, my dear friends, if at all there are any court issues, like if at all you are facing any litigation problems, like you get summons, or you get some kind of your a party to some kind of order, or you don't know that some order has been passed but you are not aware of it, whatever, if you have been implicated into a court case, irrespective, civil, criminal, or any type, never ignore it. Always go to your counsel and discuss it across, and try to face it, because the more you try to escape, or the more you try to ignore it, the more dangerous it will turn on you. It can become a cyclone and it can havoc your life. So better be careful. And that's all, my dear friends. This is all about the Contempt of Courts Act 1971. Thank you so much for your audience. Pleasure.